criminal trial's core purpose, as we know, is not to secure a conviction. It's to make sure that only the guilty are convicted and the innocent walk free. That's why we have the presumption of innocence, the burden of proof resting with the prosecution, the standard of beyond reasonable doubt, the right to a fair process and legal defense. If we start reshaping trials to heavily center on the complainant's experience, giving them legal representation, rights to challenge what evidence get in, and extensive protection, we risk drifting towards a civil-style model where the complainant starts to look more like a party in the case rather than a witness. And that comes with dangers. Too much focus on trauma might lead juries to prejudice the accused. Limiting cross-examination could exclude key facts. Training judges and lawyers in myth-busting could create a bias in disguise. The Law Commission recommends keeping juries in sexual offences trials, rejecting both judge-only alternatives and the idea of requiring jurors to explain their verdicts unless strong evidence demands reconsideration. But this position feels at odds with the concern that the jury may be swayed by myths or stereotypes. It raises a deeper question. If those concerns aren't enough to justify structural change, perhaps this reform isn't really about tackling myths and stereotypes after all. We are not saying these reforms don't have merit, but are these changes compatible with the fundamental role of a criminal trial? If we want to rethink the model entirely, that's fine, but let's have that conversation openly. Let's not quietly rewrite centuries-old principles under the cover of a reform. In short, if a trial's aim is to prevent wrongful convictions, we must be extremely careful not to tilt the scale so far that we undermine that goal, no matter how well-intentioned the reforms may be.